things that you want to look out for in terms of possible long-term care planning down the road, in terms of, financial aspects of the, giving care to a loved one, as well as taking care of yourself as part of that process as well. So there's a lot of things that people accidentally do or think they're doing the right thing, but actually things that will end up causing them issues later if they're not properly addressed. So what I'm going to do is I'm going to run you through a lot of the various things that we often see people, either accidentally do or think they're doing the right thing, or just have no real background in elder law or long-term care planning and don't even realize that what they're doing is not considered something you can do for a loved one, especially when it comes to things like Medicaid and, not accidentally causing somebody a penalty issue down the road. The holiday season, Thanksgiving, things like that, it's when we often get back together with family. And obviously that's going to be a little different this year, but it's also a great time to talk with your loved ones about caregiving and, checking in and seeing if anyone needs any assistance, which means it's also a great time to talk about things you shouldn't do and things you need to be aware of. And if you are already doing some of these things that you can, you want to start doing going forward or stop doing going forward in order to make it as smooth as possible, any potential future transition from care at home to care in a facility. So it's just something to keep in mind. But welcome, everybody. I'm Attorney Justin Randall with Hooper Law Office. Today, we're going to be talking about common caregiver mistakes, people, caring for their loved ones, things like that, not necessarily professional caregivers, but caregivers that come in as, sons, daughters, family members to take care of their aging parents or other loved ones. So, we have a couple really common things that come up a lot with this type of, area of discussion that people are either doing or are not doing. So I'm going to walk you through some of that. But as a quick reminder, before I get in too deep into this discussion, if you are participating via Zoom, you do have the ability to send in questions through our Q&A function, which I will be able to answer. I have a screen that I'm looking at where I can see them pop up. So if you have any questions along the way, please feel free to ask them. It's helpful to let me know what you guys are thinking and where it might be helpful to lead the discussion. So please, if you have any questions and you are participating by Zoom, you can use that function. Another thing as well, you will be, if you are participating by Zoom, you should be receiving an email after this with some materials. Our list of top 10 caregiver mistakes is on that list, or is one of those materials, along with some videos from our video library. The other thing that's a part of that is a feedback form. On that feedback form, you can give any feedback you want about maybe topics you'd like to hear us discuss or things that we can do to improve the process, whatever it might be. But if anything I bring up today leads you to think, oh, maybe I'd like to come in and have a consultation, or I have some concerns I want addressed, and you want to come in and speak to one of our attorneys, that's a place you can fill that out. It's it gives you a place to say, yes, I would like a consultation and here's how to contact me. We don't reach out to you if you don't fill that part out. We are only asking that if you would like us to reach out to you, that you do fill that in, because otherwise we just can't reach out to you. So please fill that out if you have any sort of concerns you want to come in and talk to us about. Our consultations are free of charge. We usually set them for around 2 hours to give enough time to discuss any issues, but they don't always take that long. So don't worry about it. If you're, worried about any fees or anything like that, those initial consultations are free of charge. To begin, what we're discussing today, like I mentioned earlier, is caregiver mistakes, common caregiver mistakes that come up. So what a lot of people don't realize when they go in and start providing care for a loved one is, you not only have to be aware of their care needs, their healthcare needs, but also what kind of planning they may need for the future. What I mean by that is, as nice as it would be for all of us to be able to receive care in our own home, for the rest of our lives, if need be, not everyone can get the care level that they need at home, especially not necessarily from a loved one who doesn't have sort of that professional backup from a visiting nurses association or whatever it might be. But sometimes long-term care facilities, things like assisted living and nursing homes, are more equipped to handle certain health conditions. So not all of us can stay at home forever, as nice as it would be if we could. Um, Care at home can be either the cheapest or the most expensive too, depending on how many hours you need someone to receive care at home. Now, if you're just paying a loved one, you control that a little bit more, but paying a loved one comes with some risks as well. So the number one thing that causes a lot of issues for people in regards to long-term care planning when they are paying a loved one for care is that they don't have the right documentation in place. What I mean by that is when you're paying a loved one, even if it's for a legitimate good or service, they're providing a service by coming in and helping you out. But if you're paying them and you don't have what's called a caregiver agreement in place, that means that if you ever need to go to a long-term care facility and you've been making these payments to your loved one for however many years, and then you need to apply for Medicaid in order to receive assistance to help pay for your long-term care. Well, Medicaid can look back at those payments and say, well, those were a divestment. You were making a gift, and we will give you a penalty for the amount that you gifted over the last 5 years. That's where you hear that 5-year look back come in. So the issue that comes up is even though you may have been legitimately paying a loved one for care needs, you're not just trying to hide money away from Medicaid, you were legitimately paying somebody to help you out. Without that caregiver agreement in place, unfortunately, Medicaid assumes that you were making a gift and you were trying to hide it from them and from being counted against you. So the caregiver agreement is essentially, it's a notarized contract that is put in place prior to anybody being paid to go in and give you care, a loved one to give you care, I should say. That then is a way that you can rebut Medicaid's presumption that you were trying to make a divestment, that you're trying to gift it away and hide it. If you can show them that contract that says, hey, I'm paying you, an hourly rate to come in and help me, and this has been notarized, it has hits all of the key factors it needs to in terms of a caregiver agreement in order to make it not countable for Medicaid or not a divestment. As long as you have all of that in place prior to any payments, they can't, you have a way to tell Medicaid, no, this was a legitimate expense. I was paying them. And in fact, they helped keep me out of long-term care facilities for a longer period of time than I would have had they not come and help me, and therefore saved Medicaid some money by not having to pay. So you really absolutely need one of those in place if you are even considering paying a family member to come in and help you provide some sort of medical assistance or daily care needs, whatever it might be. One thing to keep in mind with those caregiver agreements, and this is something that, caregiver mistake tends to be on the, caregiver's side, the person receiving those payments, even with a caregiver agreement in place, you have to remember that those payments are taxable income. So you have to still file that as part of your income tax return every year. You can't, you're not really getting paid under the table. That would still be, tax avoidance. That's still a problem. So you do have to file those as taxable income, and it is something to just keep in mind. But then again, if you are providing care for your loved one, it is still better that you are getting paid or compensated in some way for that care. You don't want to necessarily, and this leads me to another mistake that a lot of caregivers tend to make, is you also don't want to be giving care, putting a lot of effort in, and maybe taking time off of work in a way that's going to financially harm you, the caregiver. People sometimes think they're doing their parents a favor by not charging them any money to come in and help them. But if you're causing yourself financial harm by doing that as well, that's not really good for you. So you have to take care of kind of a multitude of factors when you're looking at giving a loved one care. You obviously don't want to cause them any financial harm or harm in regards to qualifying for Medicaid later. You want to be able to provide care for them, but you also don't want to hurt yourself financially or kind of come out behind because you spent more time caring for them than you could, working and helping out your own family as well. So it's just something to keep in mind. That's less of a true mistake, legally speaking, that people make, but just because there are some things you have to do to get paid fairly and in a way that won't cause a Medicaid issue down the line does not mean you should avoid getting paid altogether. It just means that there are certain things you need to do to get that in place. And I've sort of alluded to something here over the last couple of minutes that, you want this caregiver agreement in place before any payments are made. That is because these caregiver agreements cannot be retroactively applied to past payments. They must, they're only good going forward. So if you've been paying somebody for 5 years under the table without a caregiver agreement, well, you can't fix those 5 years of payments unless that person who is being paid by you is able to return those payments in full. So, it's always better to get this in place. Well, if you think I'm going to start paying my loved one for care, it's critical that you get it in place before you ever make the first payment so that you just don't have to worry about that payment even being considered a divestment for Medicaid. And for those of you who may not have watched our other webinars, just to let you know, a divestment is when you were giving money to somebody or trying to, get it off the table so that Medicaid can't count it as an asset against you, therefore, protecting it from nursing home expenses. But you're not getting something for fair market value in exchange. So, you're truly a gift and you're not going out and paying for a good or a service from a store, for example. So, why the caregiver agreement is so important for this, though, is because you legitimately may be paying for a good or service, but because it's a payment to a family member, it's very important to have this notarized contract in place saying, yes, I am paying my son, my daughter, my loved one for this in exchange for care. It's just a way to really make sure it's not countable for you. So one thing to keep in mind with these payments is that you don't want to do lump sum payments. It's very important that they're traceable back to sort of an hourly rate or, a sort of standard rate of some kind. You don't want a lump sum payment at the end, at the beginning, or, monthly lump sum payments or anything like that, because that is not a valid caregiver agreement. You need to have it based off of sort of an hourly rate, something traceable that you can calculate. Those lump sum payments for Medicaid purposes may end up causing you even more of a problem by, again, being counted as a divestment, being counted against you for Medicaid qualification purposes. So it's just something to keep in mind there. One thing that people often look at doing as well for things like this is, I won't just pay my loved one during my lifetime. I'll leave them a little bit extra in my estate plan, something through my will or my trust. Maybe I have 4 kids and originally I was going to give them all 25% of the estate, but now Johnny has been giving me care, 10 hours a week. So I'm going to actually up his to, 45% of the estate, whatever it would be, and that sounds nice. It sounds like a way to truly compensate them for things, but that's assuming that long-term care doesn't diminish the estate either. When you're talking about somebody who is already receiving care from a loved one, it means they likely have care needs that could ultimately end up leading to a long-term care facility, an assisted living facility, or a skilled nursing facility. And the problem with when that happens is that those facilities are very expensive. There's a reason people are afraid of losing the home to long-term care expenses or spending through everything they have in order to receive that care. It is expensive. So if you are planning on leaving a certain percentage in excess of what you were thinking before to the caregiver, that sounds great on paper, but if you end up needing that long-term care and you do spend all the way through your estate or a lot lower, having a much smaller estate than you originally intended by the time you pass away, the problem there is that, well, you didn't really end up compensating them for that care then. Yes, they may have gotten a higher percentage, but a higher percentage of $0 potentially is still, still zero for everybody. So it's good in theory. The thought behind it is obviously there's compassion there. There's thought put behind that higher percentage to the caregiver, but it is a very risky move because you can't guarantee that you will actually fairly compensate them then. Another thing as well to keep in mind is, regardless of whether you've spent down all the way, even if you still had your primary home when you passed away, if you're a single person and you are receiving care at a facility and you have your primary home, Medicaid won't force you to sell it during your lifetime, but they will place a lien on it. And they are able to recover against somebody's estate through a process known as estate recovery. So again, even if on paper it looks like, oh, if the home sold, maybe it's a $200,000 home. And so Johnny, his higher percentage is actually going to, lead to a higher payout. That sounds, again, it looks like it's going to be okay until you factor in that estate recovery then can come back against the estate and say, well, we paid, Medicaid paid so much in, a monetary value for your care, for your loved one's care over their lifetime. So we will recover from the estate as a creditor. So again, it is a way that higher percentage just may not end up compensating them for that care. So it is always much better, if you truly intend to compensate them for their care, that you are able to, do so while they are providing that care, not after the fact, not in lump sum payments, and not trying to do it through the estate plan. It's really something that can potentially cause a lot of issues, or just not end up with the result that you were thinking about or intended to have occur. Another thing that people often do is they say, okay, in exchange for your care, I will start to, pay for, buy your groceries for you, right? I'll pay your property taxes, whatever it might be. I'll pay some expenses for you because you're doing this care for me. Again, the issue with that is, if you have to apply for Medicaid down the road, they're going to ask, why was your mom or dad, why were they paying for your property taxes? Why were they, buying your groceries? Why weren't you doing that? And again, it will be a gift. It will be counted as a divestment, and it will cause problems for a Medicaid application. So, you don't want to try to skirt the rules here. You want to follow them to the best of your ability. You want to follow them, you want to have the right documentation in place. It's very, very important that you have a caregiver agreement before you provide care. And the question often, becomes, well, what happens if I don't have this? And how do I know when it's time to get this in place? So a couple of things, obviously, before you're starting those payments is critical. But if you don't have one in place, and say you don't have the ability, you don't have the mental capacity, you have diminished capacity, you can't sign new contracts yourself anymore. Well, how do you get this in place? That's where it's critical that through a financial power of attorney document, that your financial power of attorney agent has the authority to set this up for you. Specifically in all of our financial powers of attorney, we're saying, my caregiver, my financial power of attorney, maybe not the same person, but often are, I want them to have the authority to set this agreement up for me should they ever need to, so that I don't accidentally cause an issue for Medicaid, or my financial power of attorney doesn't accidentally cause me an issue for Medicaid, something like that. So it's just something that you want to have a valid power of attorney in place no matter what anyway. But it really goes to show you that you have to be very careful when you're setting up a financial power of attorney of what authorities you include in that. And specifically, you want authorities, a whole host of authorities surrounding different long-term care decisions that might need to be made, around planning, around paying for care, whatever it might be. You want that agent to have that authority to do so. So just because you don't have one in place already, I wouldn't expect somebody to have a caregiver agreement in place years before they ever needed care. That would maybe just be a little ridiculous for them to have. But you want somebody to have that authority to set it up for you if you can't do so yourself. So it's, just goes to show you, like a lot of things in estate planning, it's very important to have good powers of attorney in place so that your loved ones can step in and help you, right? So Another thing, I mentioned paying under the table earlier, trying to avoid taxes for payments through a caregiver agreement. That can be an issue. But another reason you don't want to pay under the table and pay in cash is people think, well, if I pay in cash, I'm avoiding any problem. There's no way for Medicaid to trace that payment. It's a cash payment. There's not necessarily, bank statements associated with it. But where that still causes a problem is that still counts as a divestment. So even if somehow they couldn't trace it back to bank accounts, if they ever found out about it, you're causing yourself an issue. You're still causing a divestment for Medicaid. So paying under the table is just not a good idea. And quite frankly, that caregiver receiving those payments is technically committing, tax fraud by not reporting that as income. So there's a few reasons there that you want to avoid doing that. But the other thing is realistically, even if you're paying in cash, where are you getting that cash from, right? You're generally withdrawing it from a bank account, and Medicaid does require bank statements. So when you report those bank statements to them and they see just, a consistent cash withdrawal of a certain amount potentially, regularly, or even in a large sum, they're going to ask you, well, where did that money go? Do you have receipts of how that money was spent? Because if not, if you can't show that that was for a legitimate good or service, like buying groceries from the store and having the actual receipt for it, well, Medicaid's going to assume that you were trying to make a gift. They function on a very different basis of evidence than our legal system is supposed to, right? Innocent until proven guilty, right? Well, Medicaid is more of we're going to assume you're guilty of making a divestment, and you have to prove that you didn't for something like this. And that's a very hard bar to meet. Especially if you were making a divestment, I mean, you're just not going to be able to prove that you weren't. Lying on a Medicaid application is a legal offense. It is committing fraud. So I would never advise anybody to say, well, just don't put the fact that you were making those gifts on the Medicaid application. I would tell them you have to still report that, even though it will cause a penalty issue for you, because one way or the other, I'd rather end up in a long-term care facility than in prison. So don't commit fraud on your Medicaid application. The other issue that people often come up with is they may say, well, I have an agreement. I have an agreement with my son or my daughter or my loved one, and I am providing, I am making payments to them. The first thing I'm going to ask to see is, okay, do you have that agreement in writing? The sort of handshake deals, I mean, in general, in legally speaking, are always bad ideas. You always want these things in writing, whether it's a real estate transaction, a caregiver agreement, an employment contract, whatever it is. Verbal agreements are the most dangerous things in the world, because then what do you go back to with proof? You get into a he said, she said situation, and that is very difficult for anybody to come out, ahead with those types of agreements. But in particular with a caregiver agreement, it's very essential, because like I said, yeah, you may have had an agreement, and you may, maybe your loved one was providing or was actually filing that income as taxes, or as reported income taxes. But if they don't have that notarized caregiver contract in place, that caregiver agreement, that is going to be an issue. You're still going to have a really, really, borderline impossible time convincing Medicaid that that wasn't a gift and that wasn't a divestment. So it's just something that you absolutely want to be very certain about going into. And, the reason that people like me have a job in this area is because there's no way for the average, person who just doesn't work in this area, doesn't have the sort of background knowledge in Medicaid or an elder law or anything like that. I wouldn't expect anyone to know to do this in advance. And it's why it's such a common issue, because people don't know the intricate rules of Medicaid, or they don't follow the updates every year. They don't know what you can and can't do. They think, even sometimes in good faith, that they're not making a divestment or that they're legitimately paying someone. But without the proper steps followed, even someone doing something they think is correct, or they don't think will cause an issue, it still does. And that's why it's really important, if you're thinking that you are going to start providing care for a loved one, or that or you are thinking about paying a loved one to provide care for you in the home, come in and talk to an elder law attorney and talk about setting a properly executed caregiver agreement, having that set in place before you ever make those payments, to avoid yourself or causing a problem for yourself down the road. So just something to keep in mind there. One other kind of last thing I want to talk about things that people often do as a way to pay a caregiver, right, is paying a spouse, or gifting assets over to a spouse. If their spouse is providing care, thinking that is somehow going to hide things from Medicaid or not make it available. In Wisconsin, regardless of whether you are the person receiving care or not, if you're married and your spouse is going into care, well, in order for them to qualify for Medicaid, they will still look at the assets of the couple as a whole. So if you're gifting all of these assets over to the spouse that you think won't need care, that sounds great. You think, oh, I'm getting it out of my name and it won't cause an issue. Well, you're not really doing anything. You're still just gifting it over to your spouse. And then when you have to file a Medicaid application, you still end up with all of those reportable on a Medicaid application. There's other planning you can do if you're looking at protecting things from long-term care. There's a lot of prospective planning you can do. There is a lot of emergency planning that you can do as well, in order to make sure that you don't have to spend down all the way. But as with caregiver agreements, you want to talk to somebody who works in this area, specifically somebody who focuses on elder law, so that the proper tools to use, what you can and can't do, and if what you're doing is going to cause an issue for you, and taking into account how long it might be before you need long-term care as well. So never think you're outsmarting Medicaid. Never think you're being sneaky or anything like that. I mean, even if you somehow outwit Medicaid on that, I wouldn't want to take that risk, because the risk is just too high. Like I said, if you're not honest on a Medicaid application, that is fraud. But if nothing else, you could have created a huge penalty for yourself, and therefore you end up with no money remaining in your own name because you've maybe gifted it all away. But you have Medicaid saying, well, we're not going to provide any assistance for you for X number of months because you gave all that money away. And then the question is who pays for that care? So I have just a couple of minutes left here. So I'm going to, as I wrap up, I just want to mention that, we do have another webinar next Wednesday, and it's what we're going to be talking about is signs your loved one may need care, and things that you can, do to sort of plan for that event, and what you can do to protect assets a little further, if that's your wish at all, and what other things you can do to plan in advance. So it's going to be a really good topic. It's one that we go back to because it's there's so much information that is either incorrect on that, or you're looking online and you may be looking at the wrong state. So it's very important that you know the signs that your loved one might need care, and what you can do to start to plan ahead for that, and what you can do to protect them and make sure that they maintain control over their care as that may come up. So I want to thank you all for joining me today. Just another reminder, if you do get that feedback form and anything I mentioned today is something you want to come in and talk about, just fill out that feedback form and mention that you would like us to reach out to you to set up a time to talk. But otherwise, have a very happy Thanksgiving. In whatever way you're celebrating this year, have a good Thanksgiving and stay safe, and enjoy maybe at least Zoom family holidays. But thanks